can start. So, welcome everyone. Thanks for making time on a weekday afternoon. Uh, I am Sanidhya. I head strategy for SafeTree, and we are all together for this webinar on IVF regulatory compliance, which we are doing for our Uttar Pradesh chapter. We have with us today our esteemed speakers, Advocate Vikas Verma, who is a Supreme Court lawyer. He is an expert in ART and surrogacy regulations. And we also have with us our CEO, Mr. Vikas Anand. As many of you are aware, he's a leader in IVF insurance sector in India. A few more words about Advocate Vikas. By graduation, he's an engineer from the prestigious Delhi College of Engineering, post which he has also spent a significant time with the DRDO. Driven by his passion for medical science, Advocate Verma also pursued extensive research and development in gynecology and obstetrics. Uh, uh, Transitioning his expertise into the legal realm, Advocate Verma embarked on a distinguished practice in medical jurisprudence encompassing a wide spectrum of its related branches, including forensic medicine, forensic pathology, clinical forensic medicine, etc. And as of now, he practices in Supreme Court of India and as well as various high courts, demonstrating his command over the legal landscape over the nation. He's a vital part of our Health Rights Associates law firm, where he passionately defends doctors, medical practitioners in a range of complex matters, including cases of criminal medical negligence. Overall, he has around 10 years of 10 years of experience in medical jurisprudence, and he brings a wealth of knowledge and practice understanding the intersection of medicine and law, particularly relevant to nuances of IVF and surrogacy. So with this, we will formally start our session, and I will hand over to our CEO Vikas Anand to just quickly brief all of you on quickly introduce all of you to SafeTree and give an overview of the market as well as what we offer. Over to you, Vikas.
Thank you, sir. Good afternoon to everyone. Today you will be spending afternoon with two Vikas. So I'm sure this will help in the Vikas of your business and also the regulatory compliance. We are organizing multiple webinars with the reputed advocates, professionals, legal professionals, so that to help the standard of governance, particularly with regards to the new ART regulations and surrogate mother. So today I'll be talking briefly about how I see the industry, fertility industry. If I look into the current scenario, we have nearly 3 crore Indians facing fertility challenge, and the number of cycles, if we see, is only 300,000, which means only 1% of the couples who are facing fertility challenge are able to afford the treatment. And we did a high level assessment based on various factors. We have grouped this 3 crores into 3 different categories. One is nearly 17%, which is having high awareness about the issues and the treatment, but they don't undergo that. So they are the ones who would be hopping from one clinic to another. There are another 20% who are aware there is a challenge with them, but they are not taking any action. And also 62% of the remaining couples have no awareness. So definitely this is a challenge. All of us, we as professionals are facing how to get maximum people get into the cycle of treatment. And it's and if I were to look into this, and I'm sure all of us would agree, the biggest challenge is the affordability. People find the treatment to be expensive. Also, the lack of awareness, as we see, nearly 62% of the people have a very limited awareness that there could be a fertility challenge. We also, unfortunately, don't have any insurance cover for that. So, lack of awareness, affordability, no insurance product definitely is one of the problems this industry is facing. And till we have a solution for this affordability insurance, there definitely would be a challenge in increasing this percentage from 1% to a higher number. If I look internationally, there are various case studies which definitely provide an indication that insurance can be a good enabler from a growth of the industry. So so on the screen you can see an example from USA, where the states which have mandatory fertility insurance, which are marked in green, have higher number of clinics per 100,000 females. The number of cycles per clinic is 1.7 times more, and overall, the number of IVF cycles per 100,000 female is 2.3x. Also, what we have seen further is, if we see countries like Israel, Japan, where we have seen with the introduction of insurance, there has been a growth in the industry, fertility industry. So we do believe, based on the international experience, that insurance does play a very important enabler for the growth of the industry. Moving further, quickly about us, we are an insurtech which help couple. We provide insurance on various aspects relating to fertility, whether it's donor insurance, surrogate mother, professional indemnity, maternity insurance for IVF, and other products. And we recently won Economic Times Excellence Award for the insurance, which was happened in Bombay last month. That's what from our perspective. Now, the more important is relating to the regulatory compliance. I know all of you, with the introduction of new regulations, are struggling, and this is an opportunity where now I'll request Advocate Verma to help us decode this regulations and help us, the clinics, how they can start their journey towards compliance. Over to you, Mr. Verma.
Thank you, Mr. Salam, for providing me this platform to reach to your audience. And
Advocate Verma, you are not audible. Just unmute.
Hello. Hello. No. No.
Yeah. Yes, now you're audible.
thank you, Mr. Vikas Verma, for providing such a nice platform to reach to your audience. And of course, there are many areas which are now merged with this new ART Act and Surrogacy Act. ART and Surrogacy Act, but if we look to the sections of this ART Act, Surrogacy Act, they also attracted various other laws also into picture, like FRRO is also very actively engaged for OCI couples, and of course our Indian penal sections, IPC and CRPCs are also clubbed into that. So we have to understand this ART Act and Surrogacy Act in a broader perspective with respect to safety while our clinic fertility banks are taking place. They are they are doing their business in this industry. It is important to understand all the nitty-gritty. So whatever I'm going to share in the next couple of minutes is all with respect to the what experience I have in the last 3 years as soon as this comes into picture and goes into
Advocate
this.
Verma, can you please move closer to the mic?
Okay, is it now better?
Volume is very low. Sorry.
Am I audible? Clear right now?
Are you using an external mic or something?
I'm not using external. I'm not using external.
Can you try muting and unmuting or changing this mic, please?
Now it is better.
Not exactly. It's still very, yeah.
Not better. It is not better right now.
No.
Not improved.
अभी म्यूट है ना कर दिया Hi, Advocate Vikas is rejoining. Please, thank you for your patience.
What is the status of this quality of sound? I'm audible.
Better now, Advocate Verma. I think we can now, start.
Yeah, it's better. We can proceed, sir.
Okay, thank you very much. Thank you very much. So, let me start with the initial side that I was about to tell that this ART Act and the Surrogacy Act is not only these two acts. If we come to the very last chapters, they involve various other acts also. That includes Clinic Establishment Act, that includes IPCs, CRPCs, and there are various other provisions are there when courts look them in a consolidated way. Recently, we are now here majorly focused on the regulatory compliance which are required. So I will cover that thing first. But my whole idea is that any organization which wanted to take the license of ART clinic or ART bank, they have to understand the risk associated with this practice, with the involvement of these new act. So the very important line every doctor has to understand is that this act says that all the donors and surrogates are presumed to be innocent. But they are majorly oriented on that part if we are taking third party donor and if we are involved with surrogates into that. Particularly important for IVF, it is important for IVF clinics, and at the same time, because ART banks are heavily involved in recruiting these donors. So it is equally important to also let them understand the legalities involved at the very inception of the regulatory process of taking the license. So please change the slide. Okay. As we know, there are two levels of clinic. ART level 1, which only have the capacity to go for IUI procedures, but more than that is IVF, ICS, and others are taken care of to clinic level 2. IUI is for 50,000 is a fees, government fees for 5 years, whereas for level 2 it is 2 lakhs for 3 years. So we have to revise it with respect to 3 years of life cycle. This is the big difference here. ART banks also has the same amount of fees of 50,000 rupees for granting of the license. Next slide, please. So whenever we have already provide our consultancies to various international and national IVF clinics and ART banks in Delhi, in Punjab, in Chandigarh. And the very first question is that what kind of a legal entity we should use to run this kind of a business. So with respect to the court, because various cases has already been initiated on certain IVF and surrogacy clinics in Delhi, in Punjab, in Chandigarh. So we understand that the best proposition is not to go either with the partnership firm or with the proprietorship firm. The best is to go with private limited at least. There are many safeguards, hidden safeguards are available with private limited. Like in one of the cases where we appeared with in Rose Avenue Court, which was a matter of CBI versus Neeraj. So where there actually what happened, the clinic took the service of the ART bank, and in turn ART bank diverted that patient to for adoption. So the case started with adoption inquiry, and the case reaches to the IVF clinic. Fortunately, that IVF clinic was a private limited concern company, and so that IVF clinic was having a pre-registered and granted activities in the form of MOA provided by Registrar of Companies under Companies Act. So due to that, they were having a mandate officially approved by the government to consult and advise for adoption also. And it was written in that service in the MOA that they can take the third party service for those organization who can provide the consultancy and later on can do the other legal due diligence or anything like that. So in that context, they were very much safe of asking their referral charges from the third party company who was actually involved in some of the adoption services. But then the other this kind of a safeguard was only available because they were having a clear-cut MOA issued by the Registrar of Companies under Ministry of Corporate Affairs under Companies Act. So that was one safeguard under the private limited company. The other is the vicarious liability. which is again very important when you are involved in such a high risk area. So whatever you are doing is for your company. If you are having a private limited company, and private limited company is treated as a third party, as a legal identity in the eye of law. It is completely different than directors and promoters of the company or employees of the company. Therefore, you have another degree of safeguard with respect to not having a direct liability on the promoters or on the directors of the company. So we always recommend, and there are a lot of judgments are there. Very recent judgment was Sanjay Dutt and others, where the apex courts, Honorable Supreme Court, firmly said that the act committed by the company cannot be directly held liable to the directors of the company. So in that case, the directors got a very easy bail, and they are completely safe, because the company is treated as a complete legal identity in the eye of law, and which is different than that. So therefore, the same was with Sunil Bharti Mittal, and we use these judgments quite often in court to protect directors and employees with respect to vicarious liability. So that is the reason we always suggest, if you are looking to go into this area, it is better that you use private limited as a commercial vehicle rather than a partnership or a proprietorship, because in the partnership and partnership, they both are equally amount to your personal liabilities, personal assets. So therefore, this is the one best approach, is to go with private limited company if you are formulating with that. Next slide, please. The other, as I explained to you, it is about the operational freedom you will get in the form of MOA, because under Section 6 of Companies Act, whatever you write in the MOA is completely verified by the registrar of companies. Once they issue the MOA to you, it means you are doing all legal acts which are permissible in India. So in that, if you are you wrote in that MOA that you are going to provide the consultancies in all channels of fertility and their possible solution and treatment, including adoption, for example, then you're completely safe in that respect, because it is under your MOA, which is pre-approved by registrar of companies. So you have another degree of shield. Again, that is only possible in a private limited company. Next slide. Now the third part is this is like another important aspect that it happens many a times when you are entering into a partnership form, let us say, or you wanted to transfer your shares or your position to your next successor in your business or in your IVF clinic. Then it is not possible in the case of partnership or proprietorship concern. As soon as you resign, the whole form get dissolved completely. Then you have to reformulate and you have to reapply for all those licenses. So it is going to be very expensive, and your trademarks and your copyrights all are going into useless approach. So therefore, if you are having a private limited company, as I said, private limited companies are treated as a separate legal identity than directors. So that directors can resign, can join, and therefore you need not to take every time a new license or revise anything. It is only a MOA is changed, and you have to just intimate the concerned state board about the change of the composition of the new board of directors in the form of MOA. So that's it. So in that case, your existing company runs quite effectively. So and that is what I explained to you, from donors, from surrogates. The best defense is to keep yourself away, separated, your all assets, financial assets, and everything separated from your company. Tomorrow, if anything, due to unfortunate reasons, any legal proceedings started during line of your practice of your medical business, then at least you and your personal assets are completely safe. They are not going to be attached by any court, at that point of time. Now, the second line of defense, which ART Act and Surrogacy Act itself says, this Section 21F basically provides opportunity for every clinic to have their own internal committee. So what happens when internal committee take place? Then it should be treated as a neutral and unbiased committee, which take care of any complaint which initially takes place. So this is a very beautiful, in fact, section to protect clinic at a very initiation of the any complaint. So the process is like that. Any patient who is being treated in your clinic, if they have any grievances, their first duty is to approach you through the complaint box, and they have to file that complaint into that complaint box first. Then only they can take any other remedy. Suppose if any clinic directly if any patient directly approach to the court or to any police station, then they don't have the power to entertain their complaint at the very first initiation, because the law says the patient has to first file their grievances in the complaint box in the ART, which is situated in the ART clinic or the surrogacy clinic or ART bank. So we always recommend that you must have a big ART complaint box at your reception, so that the complaints can be sought internally with the patient one-to-one before it takes a second level of remedy for with respect to the courts and police. So it is very important that we must have this complaint box and the complaint committee formulated inside that ART clinic and surrogacy clinics. Of course, there are different kind of members are required. An advocate is important because whatever the legal implications are there, they must be taken care well in advance on that complaint. The other important factor is that we must understand that this complaint box is very important along with the complaint register. So you have there is a protocol for that. We provide those protocols to many of our clinics who want their services. So these are the benefits. As I said, legal compliances can be improved. It limits the legal liability and definitely reduce the litigation. And we can always collect a lot of defense while we are having conversation with the patient, which can be later on time used if the fight goes into courts or in some other forum. And it also increases the quality of trust in the market, because those patients who are having a little bit amount of grievances with you or your services, if they can be handled in a better way, then of course it is very important for your own brand value also. The third line of defense is indemnity. We must have indemnity insurance for our clinic and for our doctors who are practicing at the front line. And here Mr. Vikas Anand is the right person to give you more insight that how it can really help to see any legal emergencies or in such situation. Next slide, please. Now, apart from that, because this particular session is more focused on the UP, and UP is a full state, therefore the Clinic Establishment Act is in picture, unlike in Delhi. So every clinic has to be registered, and they must have a certificate of establishment of clinic from that particular board. Apart from that, you have to have a pollution board certificates, which is another important factor. And with respect to your area, there are various Supreme Court guidelines. If the area is above of that, then you have to take up fire safeties also. Apart from that, you have to have your, if it is on the lease, the land is on the office or the premises on the lease, then the lease agreement should be at least for the minimum 5 years, because the maximum license period for one go is for 5 years. And all the doctors must have at least minimum 100 embryos